Hello friends, in this video I am going to discuss how to incorporate a company. There are defined procedures for the incorporation of a company. So in this video I will discuss the legal process defined in Companies Act. So let's discuss the procedure. As defined in Chapter 2, Section 7 of the Companies Act 2013, the concerned interested person needs to file his application to the registrar, within whose jurisdiction the registered office of a company is proposed to be situated. Next question is, what are the documents required to be submitted with the application? Along with the application, the following documents also need to be submitted. The memorandum and articles of the company, duly signed by all the subscribers to the memorandum in such manner as may be prescribed. A declaration in the prescribed form by an advocate, a chartered accountant, cost accountant, or company secretary in practice, who is engaged in the formation of the company, and by a person named in the articles as a director, manager, or secretary of the company, that all the requirements of this act and the rules made thereunder in respect of registration and matters precedent or incidental thereto have been complied with. Next, an affidavit from each of the subscribers to the memorandum and from persons named as the first directors, if any. The address for correspondence till its registered office is established. The particulars of name, including surname or family name, residential address, nationality, and such other particulars of every subscriber to the memorandum. In addition to this, proof of identity as may be prescribed, and in the case of a subscriber being a body corporate, such particulars as may be prescribed. Next, the particulars of the persons mentioned in the articles as the first directors of the company, their names, including surnames or family names, the director, identification number, residential address, nationality, and such other particulars, including proof of identity as may be prescribed, and the particulars of the interests of the persons mentioned in the articles as the first directors of the company in other firms or bodies corporate, along with their consent to act as directors of the company in such form and manner as may be prescribed. It means if a person who is already working as a director in some other company, he needs to submit that information along with the no objection certificate. Now you might have the question is, what will happen after submission of adequately filled application form along with the required documents? As defined in Section 7.2, if all the information given is correct and if there is no false and fake document, then the registrar, on this basis of documents and information filed under subsection 1, shall register all the documents and information referred to in that subsection in the register and issue a certificate of incorporation in the prescribed form to the effect that the proposed company is incorporated under this act. Furthermore, on and from the date mentioned in the certificate of incorporation issued under subsection 2, the registrar shall allot to the company a corporate identity number, which shall be a distinct identity for the company and which shall also be included in the certificate. Next, the company shall maintain and preserve at its registered office copies of all documents and information as originally filed under subsection 1 till its dissolution under this Act. And if any person furnishes any false or incorrect particulars of any information or suppresses any material information of which he is aware in any of the documents filed with the registrar in relation to the registration of a company, he shall be liable for action under section 447. Now you might have the question is, what is section 447 all about? Without prejudice to any liability, including repayment of any debt under this Act or any other law for the time being in force, any person who is found to be guilty of fraud shall be punishable with imprisonment for a term which shall not be less than 6 months, but which may extend to 10 years, and shall also be liable to fine which shall be less than the amount involved in the fraud, but which may extend to 3 times the amount involved in the fraud. So it means if someone hide some information knowingly, in such a case he might be punished for 6 months or maximum to 10 years. Along with this, he might be also fined, which is equal to the fraud that he has done, and in certain case it may be 3 times of the fraud that he has done, provided that where the fraud in question involves public interest, the term of imprisonment shall not be less than 3 years. Now you might have the question is, what is fraud? Fraud in relation to affairs of a company or any body corporate includes any act, omission, concealment of any act, or abuse of position committed by any person or any other person with the connivance in any manner with intent to deceive, to gain undue advantage from, or to injure the interests of the company or its shareholders or its creditors or any other person, whether or not there is any wrongful gain or wrongful loss. Now you might have the question is, what is wrongful gain? Wrongful gain means the gain by unlawful means of property to which the person gaining is not legally entitled. Now you might have the question is, what is meaning of wrongful loss? Wrongful loss means the loss by unlawful means of property to which the person losing is legally entitled. So this is all about the incorporation of a company.